Welcome to Education in Focus. I'm Eliana Kernodle. Today we're talking about a case in front of a California judge about gender lessons in elementary school and kindergarten. Joining me to dig into this is California reporter for the Center Square, Kenneth Schrupp. Kenneth, can you give us the background on this case before we get into kind of the latest details?
Hey, Eliana. At Encinitas, the elementary school has a buddy program in which older students are paired with younger students, in this case, fifth graders and kindergartners, and they have a sort of weekly mentorship class program together. The activities they normally participate in are things that I did in my buddy program at school too, which is stuff like gardening, arts, just fun collaborative things. Sometimes they'll read books. They read books to each other, but there are notices that go out each week to parents on what the books are. And these books are chosen by the older students themselves because they want to share them with their buddies. I think it's a sweet idea and a sweet program. Here's where things got a little weird. Teachers chose a book to read, and they also didn't notify parents about what that book was. That's because this book is the gender identity book, My Shadow is Pink, which the court ruling says is about a, quote, boy who likes to wear dresses and play with toys associated with girls. And the entire conflict about this book is, within the book, is that there is a boy who likes being like a girl. His father doesn't accept this, and his father, eventually overcomes his, prejudices to accept that the boy's color is pink and not blue. And it's a book about gender theory and gender identity for young children. Before this book was taught, one staff member allegedly said to another, and this is verbatim from the complaint, we might just inspire some sweet things to fly toward their shadow tomorrow, which does seem to suggest that the lesson had a desired outcome. So teachers read the book to the fifth grade students in preparation for the buddy program, and then the fifth graders were joined by their kindergarten buddies, who were sat down next to their assigned mentors. They're paired with the same person for each of these weekly classes. And the teacher then showed a read-along video of the book. So the father accepts his son's pink shadow not as a phase, but reflecting the boy's innermost self. And then the teachers instructed the kids to participate in what's called an art activity, in which the teachers told the kindergartners to pick a color that represents you. And then have the fifth graders trace their buddies' shadows on the ground with their choice of colored chalk. The fifth grader plaintiffs felt uncomfortable with this assignment. They felt that it contradicted their personal beliefs, and they didn't feel comfortable affirming the book's message to their buddies because they know they're in a position of trust with these younger kids and think that what was being taught to them is wrong. Because these were Christian children who felt that this was contrary to what they knew or thought was right and wrong.
So then, what's the latest in this case? What has the judge ruled so far?
Well, the judge ruled in favor of the plaintiffs, and let me provide some more background on the school and their other lessons and opt-out programs. So the judge ruled in favor of the plaintiffs, saying, okay, you need to allow for opt-outs and parental notification for gender identity related lessons in this buddy program, because the judge looked at the school's other programs and found parents always got notification and opt-out options for gender identity lessons in the human growth and development unit. The school had said, it would be too much work, and it would create an undue burden for us to create an opt-out for any related materials and classes. The judge disregarded this argument and said, you clearly offer opt-outs and notification policies for similar topics and different classes, so you should just do it here. The ruling also did find that the buddy program is a mandatory part of the curriculum. and that this lesson had violated the First Amendment for forcing the plaintiffs, the fifth graders, to quote mouth support for views they find objectionable. Because I mean, if you're a fifth grade student, are you going to engage in a lengthy debate with your teacher about morality and whether or not like something you're instructed to do is right or wrong? Many students wouldn't, some would. But this ruling just affirms parents' rights to be notified of related issues like this. A similar Supreme Court case is probably going to go the way of parents as well. In Maryland, there is a LGBTQ series of books in the English curriculum for young children. That is a mandatory part of the curriculum, and parents are seeking an opt-out for that. This case could actually provide, I mean, this is just a preliminary injunction, which means that we're going to see a full permanent injunction when the case is heard in full. But this ruling could probably influence what happens in the Supreme Court and use a citation or justification for a more national ruling.
Well, Kenneth, thank you for your insights on this story. I'm sure we'll continue to follow both this case and the case in Maryland as they continue to develop. You can follow our coverage of this at thecentersquare.com.